Yes, good afternoon to everybody. Yes, welcome to the today class. That is the law of property that we are dealing with the rights and duties of the buyer and seller. Where we are. Yes, just now I heard the sound. Again, you can read that what I put on the screen. Anyone, unmute and read.
Good
Yes.
afternoon,
Good afternoon. Yes.
Professor Dr. Muhammad Sahib Hussain, sir.
Very good, very good. So in the yesterday class, there was some disturbance would be there. I believe that because sometimes you are hearing my voice and sometimes I am not hearing your voice. But anyway, the things are gone well, and that is the reason that I could not able to, or I was not in a position to record it. Also, that's why that you did not see the YouTube link in yesterday class. But of course, this time there's everything is very much clear. I am hearing you and you are hearing me also. Yes. Rights and liabilities of the buyer and seller's removable property, Section 55 of the Transfer of Property Act 1882. So, in any property transactions, buyers and sellers are subject to rights and liabilities. In the absence of the contract to the contrary, suppose if there is no any contract between these people and say up to that extent that is the reason they will say subject to the property, that is the buyer or the seller of immovable property respectively are subject to the liabilities and have the rights and mentioned in the rules next following the such of them are applicable to the property sold. So now we will see that what are the liabilities of the buyer according to section 55, subsection 5 of the Transfer of Property Act 1882 that clearly says liability to disclose the facts. That number one is liability to disclose the facts. Yes, to disclose the seller any fact as to the nature or the extent of the seller's interest in the property of which the buyer is aware, but of which he has a reason to believe that the seller is not aware, and which materially increases the value of such interest. So, in yesterday class, I already gave that. Suppose the buyer knows that the property which is the seller is going to sell, that land is having the granite or a mica or any other natural ore it there in that land. At that time, the seller did not have the knowledge of it, but the buyer have the knowledge of it. At that instance, the buyer should have informed to the seller, yes, this mine is there, or mica is there, and so and so in your land. And still that you want to sell to the same price or not. That's why that you can ask him because there is a fair deal. Because of a man who doesn't have the nature of the deceiving anybody, that he will definitely inform the thing to the seller. Who's the seller? Really, he did not have such a knowledge. So, in the case of the Haji Isha versus Daya Bhai, that is the AR 1896, Mumbai 522. Yes, can you read that? The case law which I just now cited, can you read? Anyone can unmute and read.
According to section 55, subsection 5 of
I'm
Transfer of
speaking about
Property
the
Act.
case law. In the case of,
Yes, sir.
in the
In the
case
case
of,
of Haji Isha, in the case of Haji Isha versus Dayabai, All India Report 1896, Mumbai 522. It
yes,
has been held that it is
yeah,
the
yeah, yeah, yeah,
responsibility.
it's enough, enough. The AR which I wrote is the correct way of the writing the AR in that fashion.
All India Reports.
Yeah, can you write in the same fashion that AR?
అక్కడ పులి స్టాప్ ఇచ్చాడు సార్ అక్కడ
అయితే full stop ఉండాలనా వద్దా?
ఉండొద్దు సార్ అక్కడ.
Because it is an acronym, you should not have the full stop.
Yes, sir.
So that is the way of that. That is the reason that I did not. Whatever the Mumbai,
బొంబాయి సార్, బొంబాయి,
what is the rank there?
ముంబై.
Sir, shall I say, sir?
Yes, please. Anyone. I said.
M should be capital, sir.
M should be capital letter. Intentionally, I kept the same thing so that I would like to know whether you can notice it or not. So the Mumbai 522, that is the way of writing it. It has been held that it is the duty of the buyer, means the duty of the buyer that he should provide all the information related to the ownership which he is in know to the seller. Means whatever the information the buyer knows regarding the seller's property is concerned, that should have to be bring to the notice of the seller. This agreement is based on the principle of the equity and relation of the relations of believe the between the buyer and seller. So that is the same thing. If any property the seller is selling to the buyer knows that the property is having a lot of mine, or the value is more, or it is having the some of the raw material in it, or gold mine is there, or mica mine is there, or the granite is there. So is such a thing, or even the oil is there. So you should have to bring to the notice of the seller, because of the theory of the equity will work over there. That's the point. So liability of the payment of the purchase money. This is a next point. Liability of the, yes, it should be bold. It should be highlighted. Yes, liability of payment of purchase money. So how it would be there? Let me see. To pay or tender at the time and the place of completing the sale, the purchase money to the seller or such person as he directs. So the buyer should have to pay to the purchase money either the partly or the full, or as to the seller, or whatever the seller to whom he will direct, to that person the buyer should have to pay it. So the provided that where the property is sold free from the encumbrances. Yes, again I told you encumbrances means whether the property is mortgage or whether it is registered to somebody else, so that it should have to be known by taking the EC, that is the encumbrance certificate from the registration office. And so that is also a must. But another point also I told you that the property should be advertised in the newspaper stating that so and so property is going to be sold, going to be in sale. If anybody is having any objection or any title over that property, said bring to the undersigned or under mentioned the person on or before that thing also be notified in the newspaper. So the buyer may retain out of the purchase money the amount of any encumbrances on the property existing at the date of the sale, and shall pay the amount so retained to the person entitled thereafter. Suppose if the property is having any encumbrances over it, at that instant the buyer should have to pay that amount, and that amount will be deducted from the main amount. So because that can be indemnify the seller if such a thing is occurred over there. But the buyer himself voluntarily paid that any other charges should be there at the time the seller will not pay anything. So that is the stated over there. So the liability for bear damages. So what is the liability for the bear damages? Who has to bear the damages? Buyer or seller? Let me see it. So here, where the ownership of the property has passed to the buyer, once the property is passed to the buyer, ownership is passed to the buyer, means the physical position also given to the buyer by the seller to bear any loss arising from the destruction. So whatever the destruction comes by any other loss, the buyer should have to make it out, provided the destruction should not be from the side of a seller. So injury or decrease in the value of the property may not caused by the seller. That is the same thing which I explained just now. So liability to pay the due amount. So if the due amount would be there, who has to pay it? Whose liability would be there? So here it is clearly stated where the ownership of the property has passed to the buyer. Okay, the ownership is passed to the buyer as between himself and the seller. Okay, to pay all public charges and rent which may become a payable in respect to the property, the principal money due on the encumbrances subject to which the property is sold, and the interest thereon afterwards accruing due. So if any property would be passed from the seller to the buyer, naturally the property should not have any encumbrances. That means no charge would be there on the property, that everything should be very much clear. Then only that property will be transferred to the buyer. Suppose if any encumbrances are there, where the amount is paid by the buyer, at that instance, he can ask the seller to indemnify that amount which is spent for the encumbrances. So the principal money due on the income, any encumbrances subject to which the property is sold, and the interest thereon afterwards accruing due. So it is observed in the case of the Gangi versus Govinda, it was held that the buyer is liable to pay all the charges. Okay, the buyer is liable to pay all the charges after the sale. Yes, due amount includes revenue, municipal, or interest. When suppose if it is sold over there with the condition that you have to pay all the charges or whatever the encumbrances should be there after the passing of the property, unless until there is such an agreement would be there. At that instance, only the buyer has to pay all the charges would be there which is there on the property, because it is clearly mentioned there. Whatever the dues amount would be there or whatever the charges would be there on the property, it should be borne by the buyer itself. If such a thing would be there, naturally it is the buyer is liable to pay all the charges after the sale. So Of course, when once the sale is over, then he has to definitely will make all the charges. But before that, if any charges are there, again, I told you, unless the agreement agrees over there, then it can be reimbursed from the seller, or he can bear himself because he is agreed to bear. So due amount includes revenues or principal or interest if anything is there. So these are the things which will come under the liability to the buyer is concerned. So let us see the right of a buyer. So we have seen only the liabilities of the buyer here. So now we will see the rights of a buyer. So in the rights of the buyer, according to section 55, subsection 6 of the Transfer of Property Act in 1882, can you read anything according to? Yes, anyone unmute
According
and
to
read.
section 55 subsection 6, sir.
Yes, section 55, subsection 6 of,
Transfer of Property Act 1882.
is it the way of writing the Transfer of Property Act?
T is రావాలి sir, capital.
Then T should be capital. Okay, then O should be capital.
Yes, sir.
No. Conjunction and
Sir,
articles and
property,
prepositions
sir.
should not be capital. Then P
Sir,
should be
property,
capital.
capital.
A
P
should be
should be
capital.
capital. Then A should be capital. That is the style of writing. So now there should be comma without comma.
No comma, sir.
Because some places you will find the comma, some places you don't find the comma.
లేదు సార్ అసలు ఎక్కడ లేదు అది.
అయితే కొన్ని చోట్ల
కామా
అయితే
లేదు
పెడతారు.
సార్.
ఇది రన్నింగ్ లో పెడతారా, మళ్ళీ సైడ్ హెడ్డింగ్ లో పెడతారా, హెడ్డింగ్ లో
ఏం
పెడతారా?
లేదు సార్
యూ
అసలు.
హ్యావ్ టు చెక్ ఇట్. So
అయిన
anyway, that
తర్వాత
okay,
చూస్తే సార్.
okay. Let time being will make it out because as per the rules are some places definitely comma is necessary. So Transfer of Property Act 18. Let me see that how the Transfer of Property Act will say. Is there any comma or full stop would be there? Then we will follow the same manner what we say because this is the Transfer of Property Act. See, in the heading itself is clearly written. Did you see it?
ఓకే సార్.
See, that's why I told you. Because there is a rule
మరి
is
ఇక్కడ
there.
కామా ఫుల్ స్టాప్ ఇచ్చాడు కదా సార్.
లేదు కామా ఉంటుంది. You observe the Transfer of Property Act, comma 1882.
ఎస్ సార్.
That is the style of writing. So we cannot write the way that we want. We should write the way it is put it there in the act. So now we will come to the right to get benefit and rents. So who will get the right to benefits and rents? Buyer or seller? Once the sale is over, then the buyer will get it.
బయర్ సార్. బయర్.
Yes, where the ownership of the property has passed to him, him means buyer, to the benefit of any improvement or increase in the value of the property, whatever it may be. Either the property is made the improvement or the property value is increased. And to the rents and profit thereof, everything that enjoyed by the buyer. So it is observed in the Achtak versus Parameshwar, it has decided that the buyer is entitled to get the benefits of the maintenance done by the seller. So whatever the profits he got, sorry, whatever the property is transferred to him, either by improved by the seller or the increase in the value by the seller, but still the buyer could enjoy the such a property. So that is the one thing we can make it out. Then right to get interest. So this right to get interest, unless he has improperly declined to accept the delivery of the property to a charge on the property as against the seller and all persons claiming under him to the extent of the seller's interest in the property for the amount any purchase money properly paid by the buyer in anticipation of the delivery for interest and such amount when the property declines to accept the delivery, also for the earnest, if any, and for the cost, if any, awarded to him of a suit to compel the specific performance of the contract or to obtain the degree of its rescission. So now what the total meaning is, if the section says, suppose if the buyer paid some of the amount to the seller, okay. The rest of the amount he would like to pay it so that at the time of the registration, and he is ready to pay the rest of the amount to the seller. Suppose the seller denies to sell the property, then the buyer is having the right to file a case for the specific performance of the contract. That is one. Number two scenario I am giving. What just before I read. The buyer paid the party amount. Okay. The rest of the part that he doesn't want to pay, or he wants to not to buy such a property. Can he ask the seller to return the money which he has paid? Yes.
Sir, contract is over, sir. That's why he has to pay only, sir.
See, once the contract is made over there, when the partial amount is already paid, at the times we cannot say that I don't have the money to pay the rest of the amount. So, what about the liability of the A? Can A has to return the amount to the B? Here, the B made the breach. When the B made the breach, in that instance, A need not to return the property, means money to the B. Because he says, yes, pay the rest of the amount, I will register the property on your name. So that is the same thing that what he say, if he declines to accept the delivery, suppose, and the cost of it awarded by him, suit can compel the specific performance of the contract when B is ready to pay the amount, but A denied it, the specific performance. If it is, if it not, B is not ready, but A is ready to register it. At the time, A can ask for the rescission, stop the contract. Rescission of the contract will be there. If they want, he can return the amount which is paid by the B. If he doesn't want, of course, it is his discretion at the time. But the court will not impel, okay, you are not giving the property, you return the amount. No, I want to give the property, but he is not taking the property. So rescission will come over there. At that instance, A cannot, B cannot, what is file a case to return the property to A. Property, what is the money to B? Because B cannot ask, file a case against the A to return the money which he has taken. Because if the B is made the breach of the contract. An omission to make such a disclosure are also mentioned in the section paragraph 1, clause A, and paragraph 5, clause A is a fraudulent. So it is also given in the section itself which is fraudulent and which is not fraudulent. So that is about the liabilities of the buyer. Then we will see the liabilities of the seller is concerned. Yes, according to section 55, subsection 1 of the Transfer of Property Act, again the same mistake. T should be capital letter, P should be capital letter, E should be capital letter, then the comma should be there. Then 1882. So what is the liability to reveal the fault? Yes, seller liability. So to disclose to the buyer any material defect in the property means if the seller knows that there is some defect in his own property, so it is very clearly should have to show to the buyer that this the defect would be there in the seller's property. So of which the seller is and the buyer is not means seller is having awareness of the such a defect, but the buyer did not have such a defect. At that instant, the seller should have informed to the buyer, and which the buyer could not, with the ordinary care, discover. In that case, yes, Ganpat Ranglal versus Mangilal Hiralal, the High Court held that the seller is not bound to disclose such faults which is really known by buyer, otherwise he is in know of the information. Suppose if it is a not latent defect, it is a patent defect would be there, where we can see with your naked eye. Yet that defect cannot be shown to the or informed to the buyer. So because the buyer could use the reasonable care to see that what are the defects are not there, by physical verification he can come to know it. So it is not the liability of the fault will come if the seller has so means sold the property to the buyer, because the buyer is having the naked eye, buyer having the senses, he could see whether the property in a correct position or not, or whether it is having any defective nature or not. Yes, that was the thing, the liability of the seller. So now we come to the point, liability to the submitted document. Yes, and then what are the documents should be submitted? Let me see it. So here to produce to the buyer on his request for examination all documents of title relating to the property which are in the seller's position of power. So it is the liability of the seller would be there. Whenever the buyer asks, he has to produce all the documents relating to the subject matter of the property. So including the link document also. So these are the things whenever that buyer asks it. Suppose the buyer wants the copy of it. Yes, let the buyer will take the copy by producing the multiple copies by paying its cost. So now that was the thing which is there. The liability to submit a document as to entitlement. So to answer to the best of his information all relevant questions put to him by the buyer in respect to the property and the title thereto. So you have to not only submit all the documents, but add other entitlement which is there, it should be informed to the buyer. So in the case of the Lakshmi Das and Company versus DJ Tata, it has been held by the Mumbai High Court that if the seller does not answer for such questions, then the contract may be rescinded by the buyer. Suppose the buyer asks the several questions where the seller did not give any answer to it. At that instance, the option is left to the buyer to rescind such a contract. So that was the thing. Yeah, the buyer even having such a right to rescind the contract when the buyer asked the question to the seller, but the seller did not give the proper reply to it. Is it clear?
Clear, sir.
Very good. So liability to execute conveyance. So what is the liability to execute conveyance here? So on payment or tender of the amount due in respect of the price to execute the proper conveyance of the property when the buyer tender it to him for the execution at a proper time and place. Here conveyance means registration. Say whenever the buyer has paid over there, then the property conveyance should be given for the property to be transferred to the buyer. That means is a land or a house, we cannot transfer it just merely, but we can transfer through the deeds by registering from one name to another name, where the entire title interest is transferred to the another person. Next, liability to protect documents. Yes, what are the documents protected by whom? So between the date of the contract of the sale and the delivery of the property. So from the date of the contract of the sale for the delivery of the property, it is the burden on the part of the seller to keep the property in a safe custody. To take as much of the care and all documents of title relating thereto which are in his position as an owner of the ordinary prudence would take such property and document. So the seller should have to take all the responsibility from the date of the agreement to the till the date of the physically handovering the property or registering the property. Up to that extent, it is the burden on the part of the seller to see that the property should not be destroyed, should be in a good condition. Number one. Number two, even the document is also should not be destroyed. The document should have to keep in the good condition. In that good condition in the sense, we should have the own document where he is the owner of the property. So that is the one thing. Next is liability to deliver up occupation. So let us see this. What is the liability to deliver up occupation? To give or on being required, so required. The buyer or the such person as he directs such a position of the property and its nature admits. In the case of the Darpan versus Kedarnath, it has been held that if the seller doesn't mistake in delivering up to the position, the buyer can file a suit against the seller. I repeat, in Darpan versus Kedarnath case, what happened? It has been held that if the seller, yes, the person who sells the property is called the seller, if the seller does mistakes, what mistakes? In delivering up to the position of the buyer. So if he is done a mistake without delivering the position of the property or land to the donor, is a donor to the donee, it is not a donation, it is a transfer, selling. So the seller does not mistakenly deliver up to the position, the buyer can file a suit against the seller. So the buyer having a right to file a suit against the seller because he is ready to pay, number one, and number two, he would like to pay and he already paid. At that instance, that the seller should have to supposed to transfer such a property on the name of the buyer. So to pay all the public charges and rent accrued in respect of due to in respect of the property or up to the date of the sale, the interest on all encumbrances on such a property due on such date and except where the property is sold subject to the circumstances to discharge all encumbrances on the property then existing. So here whatever the thing would be there, whatever the charges will be there on the property. So generally any property where the seller wants to sell to the buyer, but it is free from all dues. Like suppose if it is a land revenue should be paid very much clearly. There should not be a due. Suppose if it is a house, which is the immovable property, the house rent you should have to pay it. Number one. Number two, the municipal tax, water tax, or any other encumbrances would not be there on the house. So that is the must. One should have to check it. So those are the things will come where the property is sold subject to encumbrances. So to discharge the all encumbrances on the property then existing. So it is the burden of the property buyer to see that the property should be not with any encumbrances. So right to seller, what did they say? What is the rights available to the seller? So according to section 55, subsection 4 of the Transfer of Property Act 1882, it reveals that right to get rent and profit. Okay. So before the property is given the position to the buyer, up to that extent, the owner can enjoy the property. That is the property of the rent and on profit. But once the property is transferred to the buyer at that instance, then all the rents and benefits should have to be taken by the B. So that was the thing which is clearly mentioned. So right to get interest on unpaid buying money. Okay, they say right to get interest on unpaid buying money. Yes, which is not paid over there. Then where the ownership of the property has passed to the buyer, okay, it will pass to the buyer before the payment of the whole of the purchase money. Okay, if in good faith they have given the position of the house, but they did not receive the equivalent amount. So to a charge upon the property in the hands of the buyer, any transfer without consideration or any transfer with the notice of the non-payment for the amount of the purchase money or any other part thereof remaining unpaid and for the interest of such amount or part from the date on which the position has been delivered. So now we will see what is the thing which is given. So if the interest is unpaid over there, so now the question comes over there. If the property is transferred or not. If it is transferred, then naturally, yeah, it is the profit which is taken by the buyer itself. So that is the thing. For the unpaid money, yes, for the unpaid money would be there, the interest will be taken by the seller. Suppose the unpaid money with the buyer is there. Excuse me, to charge upon the property in the hands of the buyer. So any transferee without consideration or any transferee with the notice of the non-payment, so either with the consideration or notice with the non-payment, for the amount of the purchase money, for the amount which is fixed over there for the purchase money or any part thereof remaining unpaid. So if they did not pay it once they agreed, they are supposed to pay it. So and for the interest on such amount or a part of the or part the date on which the position has been delivered. That we will see the what the Subbarao case says. In Subbarao versus Vasudev Shastri, that is the AP High Court decided that the seller is, I repeat, the seller is entitled to get interest on selling money only when the possession of the sold property is given to the buyer. Yes. At that instance only, they say. So a seller is entitled to get the interest on selling money only when the possession of the sold property is given to buyer. So when the property is totally given to the buyer, at that instance, he will get the entitled to get only the interest on selling money. The interest which is due, the selling money, of course, the capital also should be paid over there, and the interest also should be paid over there. Suppose if they paid partly, the rest of the part payment should be made in the later part. Generally, it is before the registration take place. Then every transaction should be a valid transaction to be counted. So these are the rights and duties of the rights and the liabilities of the buyer and the seller. So now you have to keep in mind, see, for each, the division would be there. For instance, right of a buyer, let me presume it. So right of a buyer, how it is earlier period, also should have to be taken. And at the present also we have to taken. So um, even including the rate also. Suppose the rate is increased over there. So if the rate is increased, at that instance, if the agreed amount is the same amount which they agreed, but even the rate is increased, later on he cannot increase the rate because it is clearly mentioned in the contract papers. So any other thing that would be there, you can ask me because we yesterday the same thing that I dealt it, but because of the various reasons you could not hear me, and of course you could hear me, but I could not hear you. That thing is happened, and hence I made the repetition of it so that you could understand in a better manner. So before delivery, after delivery, also you should have to say sometimes. That is also an important factor to make it clear in the idea when the examination such a question is asked. Says any other thing that you would like to ask me? Yes, please you can ask.
No, sir.
Yeah, because still we do have some time with us, but because it is the repetition would be there. That's why that I made it very fast without asking the questions to you more. And of course, now and then I do ask it the questions so that I could give the answer to it. So if it is answer is no, for any doubts are there, then we'll meet it tomorrow. But this time that the topic is mortgage because we studied sale, essential of the sale, mode of the sale, and ingredients. Yeah, essential means ingredients only. Then rights and liabilities of the seller and buyer. So these are the only the things we do have in our syllabus. And later part, we have to see the mortgage. Again, when you say the mortgage, it will be clearly mentioned type of the mortgage, kinds of the mortgage, and how the mortgage will be made, what are the essentials of the mortgage. Then also said another point, yes, um, they say rights and liabilities of the mortgage. These are the things you will come across in the mortgage. Okay, I will show you the syllabus so that you could have an idea that yes, unit 3 we say sale, essential feature of sale, mode of sale, rights and liabilities of the parties means here the parties means buyer and seller. There next mortgage, the kinds of the mortgage, rights and liability of the mortgager and mortgagee, that is the point. Again, the subtopic is there, marshalling and contribution and charges. These are all also topics are there where we have to see it. But tomorrow class let us
Thank you, sir.
concentrate on the motor games. Thank you very much for patient listening and have a good day and
Thank you, sir.
goodbye.
Thank
Yes,
you, sir.
this is the thing which I want to make it out. See you nice. Close end of the meeting. Yes, now take the screenshot. Yes, take the screenshot. Leave the meeting. Yes, leave the meeting. End of the meeting.